Good afternoon and welcome to the Court of Appeals. Appreciate you being here this afternoon. I think we've got 4 cases on our docket. Before we get started, I want to run over just a few ground rules, make sure everybody's on the same page. First of all, each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you've introduced yourself, but before you begin your argument. You may reserve up to 5 minutes of rebuttal time if you so wish. Other thing that I think is very important and sometimes is forgotten when we begin our arguments, and that is these arguments are being live streamed over the internet. So please think about what you're about to say. Sometimes it's difficult to put the toothpaste back in the tube after you've squirted it out. So just be aware of that. Don't want to embarrass anybody and don't want anybody to be embarrassed either. Let's see. Your panel this afternoon will consist of Judge Skip Frierson, Judge Christy Davis, and I'm Steve Stafford. Anything we need to take up before we call the first case?
Yes, Your Honor. On this first case, there's a preliminary issue that I will let the attorney Mr. Ward explain.
All right.
Good afternoon, Your Honors. The preliminary issue in this case is that my client, which is Washington County, is designated as an appellee. We were actually an intervening party in the underlying matter, and so our position is actually adverse to the position of the true appellee. So we had a question about how time should be allocated. Mr. Ballard for the state has a lot of arguments, and he's going to need his full 15 minutes. I have not filed a motion asking for any separate time to be set aside, but under the circumstances, I wanted guidance from the court as to whether I might be granted a few minutes to address any questions the court may have, or if the court would prefer me just to submit my arguments on briefing, and I will defer to whatever the court wishes me to do.
I thought you were just an amicus.
I thought I was as well, Your Honor, and then I was told I was an appellee. So we thought we were in a position as an amicus because we were really addressing an issue where we weren't a true party. But then we were advised that we were being treated as an appellee, and our brief was being filed as an appellee brief, and we've been designated as an appellee since that time.
Were you a party in the trial court?
We were not a party in the trial court other than an intervening party. We were a party initially when it was in federal court, but not in the trial court, state trial court level.
What's the position of the respective parties? Are they a party?
Pardon, Your Honor?
Are they a party?
I honestly don't know at this juncture, Your Honor. They did go ahead and file the brief as an amicus, and then it was my understanding that the court had ruled that they were, in fact, an intervener. But regardless, Your Honor, we don't take a position as to whether or not Mr. Ward has time to speak today.
Okay, thank you.
Your Honor, plaintiff parties...
Don't mind, pull that down, please. Thank you.
Thank you, Your Honor. Plaintiff Mr. Murray would concur with the position of the state of Tennessee and Mr. Ballard. It's pretty clear that the county is an intervener at the trial court level. Certainly, they were a defending party in federal court in this case, but presently styled an intervener and evidently now an appellee. We have no objection to the court granting the request for time, should the court be inclined to do that.
I tell you what, in an abundance of caution, let's give them 3 minutes. We'll treat them as an appellee then, and give you 3 minutes that work with you. 3 minutes. Just add 3 minutes to the time of, to the appellee. Does that work for you? We want to be fair here, and since I don't think it's the best practice to make that decision on the run, we'll let you have some time, and then we'll decide whether you're a party or not. Okay, you may call the case then.
Robert D. Murray versus State of Tennessee et al.
Are you still adjusting the clock? I see it moving.
Yeah.
Good afternoon. May it please the court, my name is Allison Jackson, and I'm with the law firm Edgerton, McAfee, Armistead, and Davis, and we're pleased to represent Robert Murray in this action. I would like to reserve 3 minutes for rebuttal, please.
All right, you may proceed.
Mr. Murray is a former state employee who was terminated from his position as a deputy clerk in the Washington County Election Commission because of his age and disability, without his employer ever engaging in the interactive process or considering the need for any reasonable accommodation. State defendant's argument that Mr. Murray was an employee of the county is barred by issue preclusion or collateral estoppel in this case. In Mullins versus State, the Tennessee Supreme Court articulated the proof required to invoke that doctrine, which includes proof of 5 factors. State defendants challenge only 2 of those here. State defendants argue the state was not a party or in privity with a party to the proceeding in federal court, and that the state was never afforded a full or fair opportunity to litigate the county or state employee issue. Both arguments fail. The state was a party to the district court litigation since the beginning. The Washington County Election Commission has been a party since Murray filed suit in October of 2017. Stewart, in her official capacity, has been a party since Mr. Murray filed his first amended complaint in December of 2017. It is well settled that official capacity lawsuits are a way of pleading an action against an entity of which the officer is an agent. That's Seiler versus Scott. Thus, the state has been a party to the district court proceeding since before Judge Reeves entered the September 7th, 2018 order declaring Mr. Murray a state employee. The state has had a full and fair opportunity to litigate the county or state employee issue. The state had an opportunity to litigate by and through both the Washington County Election Commission and Stewart, who were capably represented by the state's Attorney General, when they filed their motion to reconsider the district court's September 7, 2018 order. They argued, unopposed by Mr. Murray, that the district court ought to declare Mr. Murray a county employee. The state also had an opportunity to litigate by being able to appeal the September 7th, 18 order, or ask the district court to certify that question to the Tennessee Supreme Court. The state did not do either of those things. Instead, the state defendants proceeded with the litigation and raised defenses and immunities that were only available to the state of Tennessee. Moreover, the district court correctly determined that Mr. Murray was a state employee. State defendants believe that the district court errantly relied upon Ellis versus Bradley County, Tennessee, because they think the decision and the Sixth Circuit Court of Appeals affirmation of that decision, finding that election administrators are state employees, is wrong. The district court's analysis in Ellis and its application in this case was not errant. State defendants simply don't like the result. In Ellis, that court articulated 3 factors for determining whether a person is an employee of the county or the state. Those factors here show that Mr. Murray was a state employee. State defendants want to argue that the county was Mr. Murray's employer because it paid the Washington County Election Commission's employees' salaries and benefits. This fact is completely irrelevant because the county was statutorily obligated to do that. It had to fund the operations of the Washington County Election Commission and had only very limited discretion to adjust that budget. The significance of the county's potential liability for any judgment rendered against Stewart as a fiscal agent fails for the same reasons. State defendants assert that Mr. Murray had no authority to perform any of his clerical duties outside of county lines. This argument fails because Stewart delegated her statutory duties to Mr. Murray, duties that extended beyond the county's boundaries, such as inputting new information into Voter Central, making address changes in Voter Central, and sending and receiving daily reports to and from the state. Finally, state defendants say that Stewart and all of her deputy clerks owed their duties to the citizens of Washington County alone. This argument is narrowly focused on only the management of elections within the county and the collection and tabulation of local votes. However, the Washington County Election Commission's employees do have those responsibilities, sure, but Stewart and her clerks have duties that extend beyond the county confines. They owe duties to the public, to the candidates for public office, members of the legislature who assist in redistricting, and the State Election Commission. State defendants also identify other considerations, including statutory authority at Tennessee Code Annotated 212-210, which they say precludes the conference of state employee status upon Mr. Murray. As the Ellis Court noted about that very statute, the limiting language of the statute and the U.S. Supreme Court's specific admonition to federal courts requiring them to perform independent evaluations of a challenged official's status weighs against finding clerks to be county employees. Mr. Murray's state law claims were timely filed. State defendants want to argue that Mr. Murray's state law claims were not, and that argument is specious, particularly in light of 28 U.S.C. 1367D and the Supreme Court's holding in Artis versus District of Columbia. Stewart terminated Mr. Murray's employment on February 23, 2017. Mr. Murray filed suit in district court on October 12, 2017, only 7 months and 20 days later. In his original complaint, Mr. Murray pled facts that state claims under the FMLA for interference and retaliation. When he did that, the clock stopped running on the statutes of limitation on his state law claims, pursuant to Section 1367D. Once he received his right to sue letter, Mr. Murray moved for leave to amend, and he wanted to file his second amended complaint. He did that on November 13, 2018, to add claims for age and disability discrimination and retaliation under federal and state law. Notably, state defendants did not object to or oppose any of that. Mr. Murray's claims of age and disability discrimination and retaliation relied on the same facts as his claims under the FMLA, arose out of the same conduct, transaction, or occurrence pled in the original complaint, and thus his amendment related back to the date of the filing of the original complaint, which was October 12, 2017, pursuant to Federal Rule of Civil Procedure 15. Then, on December 5, 2019, the statutes of limitation on his state law claims started running again when the district court dismissed Mr. Murray's claims without prejudice. Mr. Murray filed suit in state court on December 26, 2019, only 21 days later, and only 8 months into the running of the 1-year limitations period on those claims. But the trial court didn't get everything right in this case. The trial court erred when it granted state defendants' first motion for summary judgment because numerous, significant, genuine disputes of material fact existed. Mr. Murray has identified with specificity and citations to the record 6 genuine issues of material fact in his brief in this case and his reply brief. Based upon the record alone, the trial court's order is reversible. For example, there's a genuine issue of material fact whether Mr. Murray was an individual disability because state defendants regarded him as having an impairment that limited one or more of his major life activities because they believed he couldn't do his job because of an incorrect Alzheimer's diagnosis. We know that a person is an individual with a disability.
Let me interrupt you there. Does the record bear out, though, that although he may have, that the commissioner may have initially thought that he couldn't do his job because of the Alzheimer's. Ultimately, though, she came to know that that was an incorrect diagnosis, and that was not the basis of the disability down the road. Is that a fair statement under the record?
It is correct that certainly Stewart did come to know that the Alzheimer's diagnosis was incorrect, absolutely. But notwithstanding that, the testimony shows that Stewart believed that Mr. Murray could not learn the job, and she attributed what she later characterized as his poor performance to him having been diagnosed with what she believed at the time was Alzheimer's disease, even though she later learned that was an incorrect diagnosis. Now, notably, the state defendants never discussed with Mr. Murray any of the potential accommodations for the symptoms of an Alzheimer's diagnosis, but Defendant Stewart has testified also that she wasn't aware that there was a state or county policy, and she had no knowledge of what the interactive process even was. I hope that answers your question. So certainly a person is an individual with a disability if he's being regarded as having such an impairment. We would submit to the court the trial court erred in failing to consider Mr. Murray's argument and the supporting evidence under the regarded as prong, even though it was argued in his brief and at oral argument. There's also a genuine issue of material fact, whether Mr. Murray was qualified for the position of the deputy clerk, with or without a reasonable accommodation. Under the Barnes case, we know a person's qualified if he can perform with or without accommodation the essential functions of the job. Those essential functions are fundamental duties, and there is a huge dispute, a genuine issue as to what those essential functions are in this case.
Who has that burden of proof?
In this case, Your Honor, to carry their burden, the state defendants had the obligation to show that Mr. Murray could not perform the essential functions of the deputy clerk job, accommodated or not.
But who has the burden of proof as to what those essential functions are?
The state defendants, Your Honor, do have that burden to show. And in this case, they have not articulated any job description, and the evidence that has been proffered by their own witnesses shows many inconsistencies in what the duties of the deputy clerk job actually entailed. And certainly, as is detailed in our brief, there were substantial factual disputes as to what those essential functions were. Certainly, Mr. Murray hasn't admitted in any way that he was not qualified. The analysis of whether a person is should focus on the time frame when the decision's made. We submit that the trial court was wrong when it considered the fact that Mr. Murray had applied for disability benefits 45 days after his employment was terminated. Certainly in the ADA context, we know that that would not preclude him from bringing a disability claim, but the result under the TDA is unknown, but we submit it should be analogous. In sum, there are numerous genuine issues of material fact in this case which warrant the court's attention. The court, we believe, should affirm the trial court's decision with respect to the second motion for summary judgment and the timeliness of Mr. Murray's state law claims. However, the court, I'm sorry?
You used your time.
Thank you, Your Honor.
May it please the court. My name is Jay Ballard. I'm from the Attorney General's office, and we represent the appellees in this action. We ask this court to determine and hold that the plaintiff was a county employee employed by Washington County Election Commission. But if the court determines that Mr. Murray was in fact a state employee, this case should be dismissed because the plaintiffs failed to meet the applicable statute of limitations, because the federal savings statute does not apply to the state of Tennessee. Finally, if the court determines that he was a state employee and that the statute of limitations was met, the trial court's decision should be affirmed because Mr. Murray could not show a prima facie case. The state, at least the appellees, provided legitimate non-discriminatory reasons for termination. And finally, there was no pretext. Turning to the issue of the state-county employment, the state did not have a full and fair opportunity to contest this issue in federal court. The decision that Mr. Murray was a state employee occurred prior to any state participation. Once the federal court made that determination that Mr. Murray was a state employee, the Attorney General's office became involved in the case. We did file a motion to reconsider. That motion to reconsider was denied. I should point out in that motion, what we requested was an opportunity to be heard and to develop facts that would help inform the court when making that decision. I'd also like to point out, after that motion was denied, the State Election Commission was added as a party, as was the state of Tennessee, so neither of them had been named prior to the denial of the motion to reconsider. But with regard to the motion to reconsider itself, as I said, we were seeking facts that we could supply to the court. It's been alleged that perhaps we should have gone ahead and sought an opportunity to certify questions to the Tennessee Supreme Court on the issue. But that was actually attempted in 2010 in the Peterson versus Dean case, which is 2010 Westlaw 5184794. And the Tennessee Supreme Court declined, saying in part, they required additional facts that are not available to this court to make that kind of a decision. Some of the facts that we developed in this particular case were such things as Mr. Murray was, when he was hired by the Washington County Election Commission, he filled out paperwork from the county. He filled out paperwork saying he was a county employee. He was in a county building. He had county insurance. He had county retirement benefits. In addition, it was determined, and at least the federal court held, as the county urged, that they were the fiscal agent of the Washington County Election Commission and could be responsible for any judgment against them. All of those things tend to show that Mr. Murray was a county employee. Now, what they allege or what they rely on is one factor. They're trying to turn this into a one-factor test. You have the State Election Commission, which appoints the County Election Commission. The County Election Commission appoints an administrator, and the administrator appoints a staff. They say, well, all of those things are one big line from state all the way down, so everything must be state. But that's not always the situation. State employees do from time to time supervise county employees. In larger counties with district attorneys or trial courts, that happens from time to time. That can't be the assumption. That's why we have a three-factor test. The Durham test and the Stambaugh test, which were mentioned by the appellant, that were in the Ellis case. First question is, who paid? There's no question in this case that all of the money that was paid to Mr. Murray came from the county. The second issue, is there any authority beyond the borders for Mr. Murray? Certainly not. He could only work in Washington County for the Election Commission. And whether there was a duty to the county alone is, I understand what they say, is they say that, well, he did state elections, federal elections, he did municipal elections, county elections, all of those four. But the fact that he did federal election work doesn't make him a federal employee, no more than he was a municipal employee, no more than he was a state employee. What he was doing was gathering the votes for the people of Washington County in all of those elections. His duty was to the people of Washington County, and therefore he should be determined to be a county employee. But if this court certainly disagrees, then the statute of limitations wasn't met in this case. There's no question that Mr. Murray filed his state law claim more than 2 years after he was terminated. And the statute of limitations concerning the Tennessee Disability Act and the Tennessee Human Rights Act is 1 year. So there's no disagreement there. And I would also concede that if this federal saving statute did apply, I have no qualm with the way they've calculated that tolling time. So it would have been timely. But 28 U.S.C. 1367D simply does not apply to the state. These facts, almost completely identical to the ones that we have here, were argued before the U.S. Supreme Court in Raygor versus Regents of the University of Minnesota. And they determined that where the state asserts 11th Amendment immunity in the federal court, that prevents a plaintiff from using the federal saving statute. I should also point out that subsection A of that provision, which grants supplemental jurisdiction in the first place, also doesn't apply to the state. But in Raygor, they said, okay, we know A doesn't apply. There's no supplemental jurisdiction if a state asserts 11th Amendment immunity. But they hadn't yet decided about if the tolling provision nevertheless applied. And in Raygor, they said, absolutely, it does not apply. The plaintiffs rely on Artis versus Washington, D.C., but that case has nothing to do with Raygor for a few reasons. First, when the plaintiffs say that Artis overturned Raygor, and I would just first point out that when you look at Artis, it talks about the two cases it overturned. Raygor wasn't one of them. Raygor is only mentioned in a footnote when they talk about the way Raygor talked about tolling, and Artis is a case about how you calculate that tolling. But more importantly, when you look at what Washington, D.C. actually is, who the defendant was in that case, Washington, D.C. doesn't have 11th Amendment immunity. They're a municipal body. They couldn't assert what the state can assert. They can't assert 11th Amendment immunity, so it wouldn't even be applicable. Moreover, if you look at cases decided after Artis by state courts, if you look at Georgia, Green versus Department of Corrections, which is 365, Georgia Appeals 592, in Minnesota, Miller versus Board of Regents, or Missouri, Brandt versus Curators of the University of Missouri, which is 616 Southwest 3rd, 494, all of those courts don't discuss Artis. They just apply Raygor. And I would say, at least based on my research, which I would like to think is somewhat reasonable, I have not been able to find a state court in the United States that has not adopted Raygor in response to these allegations. I think this court would be, or Tennessee would be alone in that respect. But turning to the issue of whether plaintiff was actually able to prove their case, I'm going to start with disability. Well, let me jump ahead just a little bit to age, because they do mention the age discrimination claim. There's no age discrimination claim here. The person who hired Mr. Murray was older than Mr. Murray. The other person that was hired with Mr. Murray was older than Mr. Murray. She excelled, Mr. Murray did not. In his deposition, Mr. Murray agreed that he had no reason to believe age played a part in his termination. It's simply not an issue. Jumping back to the disability claim, we have to first look to see whether plaintiff presented a prima facie case, and it's their burden to present a prima facie case. Then the state has to provide legitimate non-discriminatory reasons for the termination, and then it's the plaintiff's burden to show pretext. So turning to the prima facie case, and this is about his neck, by the way. This gets a little conflated. The only argument is his neck constituted a disability. So was he qualified for the position? And I find this to be a very interesting case for an employment lawyer, just because oftentimes people tend to lump in, did they do the job, into the were they qualified portion. And I think that's wrong. It's really, were they qualified? Could they do the essential functions of the job? Well, in this case, he could not, and we know he could not because he filed with the Social Security Administration saying he was 100% disabled. He said, I can't do any job. Now, the U.S. Supreme Court looked at how to reconcile these types of claims in the ADA context. And because it doesn't make a lot of sense. How can you say you can do the job and say you're 100% disabled? Well, the way you can do that, so says the Supreme Court, under the Social Security Administration, they're just looking at, is there a disability? Whereas under the ADA, they're saying, could you do it with an accommodation? So those two things could be reconciled. And the U.S. Supreme Court said, the plaintiff has to be able to reconcile those things. We're going to put the burden on them. Well, the difference in the context that we're dealing with is the Tennessee Disability Act doesn't have an accommodation requirement. So it seems, and this is not an issue that's been raised to my knowledge or decided by a Tennessee Court of Appeal, is when you actually file that 100% Social Security Administration disability claim, how can you possibly say you're qualified over here under the Tennessee Disability Act? I don't think those two things can be reconciled. But even so, it's something that would be the plaintiff's burden, even if it could be reconciled according to the U.S. Supreme Court. And if you look at what he actually said in that filing, that he had that his strokes limited his math skills, short attention span, didn't want to be around people, needed reminders to bathe and shave, his memory, understanding, following instructions, completing tasks, all of those things were affected. And turning briefly to plaintiff's issue with the essential elements of the job, this is where that would come in under the qualified part, whether he's qualified. And it is their burden to show. Now, if we disagree with those elements, the state would have to prove otherwise. And it's unclear, at least to me, what they're even claiming the essential elements of his job were. They say that we're not showing any, but he, at least in his deposition, he said filing, processing new voter applications, and address changes were all part of his duties. He couldn't do that. The undisputed proof from all 4 people that worked there said that he couldn't do that. But I'm sorry, I'm jumping a little bit ahead to the reasons for the termination there. So the other issue is plaintiff has to show that he was disabled to present a prima facie case. And we just rely on Bennett versus North America for that because it's very, very similar to the case that we have here. And the last element of the prima facie case, showing cause between the disability and the termination. The only thing that they show is he was terminated the day before he was supposed to go to a consultative visit concerning his neck. That's it. There's no indication that anyone maligned him because of his neck problem, that anyone said nasty things to him because of his neck problem, that they discriminated against him in any way. And the legitimate non-discriminatory reasons that the state supplied, I believe, certainly stand. And again, these don't have to be reasons associated with the essential elements of the job. These are just because it's an at-will state, they just have to be legal reasons to go ahead and let him go. And he couldn't do any of the functions that were required by the court, whether that be downloading reports, managing files, giving information to voters. He slept on the job. He was in a bad way, and they did the best that they could to help him along, but ultimately had to let him go. Turning briefly to the regarded as disabled claim, our defense, of course, is, as Your Honor suggested, that the Alzheimer's diagnosis occurred, and what the transcript says that Miss Stewart, what it says that she looked at or determined was, well, maybe that's the reason for his poor performance. Now, importantly, she didn't say, I think now that I know he has this condition, he's doing a bad job. That's what discrimination is under the Tennessee Disability Act. It is learning about someone's disability and then taking action against them because of your assumptions and all of those things. But under the Tennessee Disability Act, you get to evaluate their performance. And just her saying he was doing a bad job, you've told me he's got Alzheimer's, well, maybe that's the reason. Nothing wrong with that. And moreover, she learned that he didn't actually have Alzheimer's. And that was well before he was actually let go. So for these reasons, the last thing I should also point out, it's in the briefing, but I don't know that it was discussed today, but there's no retaliation claim that's viable here because the plaintiff didn't engage in any protected activity. So for those reasons, the Appellee's request that this court determine that Mr. Murray was a county employee, and if he was not, and he was his state employee, then we would request that this case be dismissed because the statute of limitations was not met here. But if the statute of limitations was met, then we ask that the ruling of the trial court be affirmed because Mr. Murray did not properly present his case. Thank you, Your Honors.
Thank you.
May it please the court, I'm Jeff Ward representing Washington County. Washington County's only issue is the issue as to whether Mr. Murray is a state employee or a county employee. Initially, at the outset, I would say to Your Honors that if the court affirms the decision that the trial court got it right, that there was no sufficient evidence of discrimination, that's going to moot this issue entirely, and the court never needs to reach it. But if the court reaches this issue, then what we would say is initially the same things that the appellant said was, A, that issue is collaterally estopped. It was litigated in federal court. The state had the right to and did try to raise that issue again in federal court. And in federal court, they could have pursued that issue further if they had wanted to preserve it in federal court. We would add to that and say there's actually a claim preclusion res judicata element as well, because that case was dismissed by the parties in federal court. The stipulation of dismissal was filed, and no one elected to appeal that issue to the Sixth Circuit Court of Appeals to keep the issue alive. So it became a final judgment, and we would submit that that determination is res judicata. On the third element, our position is the same as what the appellant said, was that the federal court got it right, that control is all in the hands of the state. No question that Washington County, by statute, is designated as the fiscal agent for the election commission and the employees of the election commission, but all the control is at a state level. The state had the appointment control. The state's appointees then made the determination on termination, and the county had no involvement in the decision to terminate Mr. Murray. So we would submit that the federal court got that issue right to begin with, that there's no ability to relitigate that in the state level, and that county should remain a mystery in this case as to whether it's a party or an amicus. Thank you, Your Honors.
I don't think there's a caption on the opinion for the mystery party or... Thank you. I believe you have 3 minutes.
I do, Your Honor. Thank you. Your Honor, to just address a few of the points that were raised by Mr. Ballard in his argument, one of which is how to reconcile the decisions of the court in Artis and also in Regor. Artis was a decision that was made by the court to clarify the meaning of Section 1367D and to specifically talk about how that statute is intended to suspend the statutes of limitations for 2 adjacent time periods, while the claim's pending in federal court and for 30 days post-dismissal. The intention of the court in doing that was to eliminate a serious impediment for plaintiffs to access federal courts when they have both federal and state law claims. Mr. Ballard's correct. There was no express overruling of the case, Regor. That is true. However, Artis is absolutely more recent precedent, decided in 2018. Regor was decided in 2002. Moreover, the Regor case absolutely does apply to states. Certainly in 1367E, it clarifies that that Washington, D.C., District of Columbia is absolutely considered a state in this context, and the court makes no distinction whatsoever as to how a state would be distinguished, or if at all to be distinguished from Washington, D.C. Further, to clarify, certainly Mr. Murray would take issue. The state seems to think that there is no requirement to accommodate under the Tennessee Disability Act. We disagree. The Barnes case makes pretty clear that an employee is qualified for a position if he or she can perform that job with or without a reasonable accommodation, the essential functions of it. That's the Barnes versus Goodyear Tire and Rubber case. After Barnes, the U.S. District Court in the Middle District stated in dicta and without citation that the Tennessee Handicap Act elements are very similar to those of the ADA, but don't include a reasonable accommodation component. The Court of Appeals relied on that to find that private employers and city employers don't have a duty to reasonably accommodate. That was the Bennett case and the Black versus City of Clarksville case. Then the Middle District followed Robertson further to find that the TDA does not require reasonable accommodation for a city or county employee's disability. But none of these courts had the authority to overrule the Tennessee Supreme Court's decision in Barnes and its substantive holding that there is an accommodation requirement. The Barnes analysis of the qualified prong has never been overruled. Thank you, Your Honor.
Thank you. Thank you, counsel. We appreciate your argument. We will consider your brief, your argument, and we'll attempt to get you an opinion resolving this issue, at least at our level, at the earliest possible convenience. Thank you. You may be excused.